3 minutes. Thank you for your patience. Hi everyone, a very good evening to each one of you. It is extremely a pleasure to address you at this 75th session of Zen Tax Talks. So today marks a very special day and we are deeply grateful for your continuous follow and your continued participation in all our webinars. So for the 75th session, so doing it continuously for the last 75 weeks has not just been a very simple task. So we thank our entire team, our entire Zentax team, who have made it extremely and very much dedicatedly possible, such that knowledge transfer happens every week without a break. So 75 weeks we have been able to do these sessions of Zen Tax Talks, and it has been very much possible with the support of our team, and the most important thing, your active participation and your motivation for us to really keep doing things. So today we are at part 2 session of the GST Appellate Tribunal Procedure Rules 2025. So a couple of weeks back, we already discussed a significant portion of the GST Appellate Tribunal Procedure Rules. And today we are discussing about the second portion of the same rules. So a quick recap on what is the major things that we had discussed in the part 1, and then we will immediately move forward into part 2. So if any of the members, participants have any questions relating to part 1 or as well relating to part 2, you may start putting it on the query box, and so that we will be able to take it during the course of the discussion, so that we will take it together as part of the session and the webinar today. So as always, that we definitely say, katrathu kaiman alavu kalladadu ulagalavu. So we are sharing with you the very limited understanding that we have got through the reading and the learning of these GST Appellate Procedure Rules, and also sharing with you our practical experiences or the learnings through our various CESTAT hearing appearances. So whatever is your learning or whatever is your experiences, you do please share it with us, so that we will definitely collectively take it together. So with this note, we will get started with a quick recap on the discussion that we had in the earlier session, the 73rd session of Zen Tax Talks. We had this detailed deliberation on part 1 of the GST Appellate Tribunal Procedure Rules. So the GST Appellate Procedure Rules were notified on the 24th of April 2025, and that is what we have been discussing so far. So any reference to the rules that we discuss or that we discussed in part 1 or that we discussed today relates to the GST Appellate Tribunal Procedure Rules, unless and otherwise it is specifically stated it relates to the CGST rules. So when I refer to the provisions of section 101, then I would talk about the CGST rules, but in all other generic perspective, the discussion today is focused towards the GST Appellate Tribunal Procedure Rules. So here, the first and foremost, the need for this professional dress is that when as an authorized representative, we appear before the GST Appellate Tribunal, it is extremely very important that the dressing is as per the professional conduct, which requires a coat and a tie. So here I am seated in a very professional manner to appear before the GST Appellate Tribunal. This is a very important legal provision which needs to be noted into account, because when we appear before the departmental authorities, be it in the matter of the Commissioner Appeals or the adjudicating authority or any lower authority, we appear in a very formal professional attire, but will not require or necessitate the wearing of a coat and a tie. But whereas when we read through the provisions of the GST procedure rules, rule number 77 read with rule number 122, it very clearly brings out that the authorized representative or any person appearing before the GST Appellate Tribunal is required to wear a professional dress, which requires a coat as well. So moving forward, whether the appeal is to be filed online or the appeal is to be filed offline, the substantial provision of the rule talks about that it has to be filed online. When it comes to the hearing of the cases, the hearing, it generally talks about hearing in a physical mode, and on the permission of the president in selected cases only, the hearing is going to be the electronic mode. That is what rule 115 discussed about, and that is something which we already discussed in the previous session. Pre-deposit for filing an appeal before the GST Appellate Tribunal contained in section 112 of the CGST Act very clearly provides that 100% of the admitted liability plus 10% of the disputed liability. Question may arise that at the time of filing an appeal before the Commissioner Appeals or the First Appellate Authority itself, I have already paid an amount to the extent of 10% of the disputed amount. Now, is it sufficient or should there be an additional amount of pre-deposit? The law is very clear that an additional pre-deposit to the extent of 10% is required to be paid at the time of filing an appeal before the GST Appellate Tribunal rules, as is contained in the provisions of the CGST Act, section 112, subsection 8 of the CGST Act. In addition to the pre-deposit, which is the mandatory case even with respect to the first appellate authority, but when we go to the second appellate authority, that is in the case of the GST Appellate Tribunal, it is mandatory that there is the payment of a fee, which is provided in Rule 110, Sub-Rule 5 of the CGST rules. Here I very specifically mention that it is the CGST rules. And what is this amount of fee that is to be paid? The amount of fee that is to be paid is ₹1,000 for every 1 lakh. So it is not to say an ad hoc amount of 1%. It is very clear to say that it is 1,000 for every 1 lakh of the tax amount in the order appealed against. The maximum amount is pegged at ₹25,000. The minimum amount to be paid is ₹15,000 for ₹5,000 for filing of an appeal before the GST Appellate Tribunal. The time limit for filing an appeal is contained in section 112, subsection 1 of the CGST Act, which is to be read along with Rule 3 of the GST Appellate Tribunal rules, which provides that the appeal has to be filed within a period of 3 months. And if the last day is a holiday or a subsequent or a set of holidays, then such number of days will be excluded. Then you will be able to get that additional number of days as is contained in Rule 3 of the GST Appellate Tribunal procedure rules. The GST Appellate Tribunal working hours, the administrative office will work from 9:30 a.m. to 6 p.m. The bench of the tribunal, the sitting hours of the tribunal will be 10:30 a.m. to 1:30 p.m. and thereupon from 2:30 p.m. to 4:30 p.m. If at all a matter had to be adjourned, then it had to be sought before the concerned bench. But if on some selected cases based on the approval of the bench and the registrar, it can also be sought in the chambers of the appellate tribunal. If for any reason that the GSTAT itself is not functioning on that specific day or that specific bench is cancelled, then the matter would be adjourned even after the preparation of a cost list. That is something, the cost list is the list of cases that are to be posted before that specific bench of the GST Appellate Tribunal on that specific day. Therefore, even after preparation of the cost list, if for any reason that it is not functioning, then the matter would be automatically adjourned as is contained in Rule 39. Rule 42 goes to say, if the appellant, the person who has filed the appeal before the GST Appellate Tribunal is absent, does not appear on the date of the hearing, the Appellate Tribunal may dismiss the case, prima facie, or it may hear the case on merits and decide. It is the discretionary power of the GST Appellate Tribunal. In this situation, it can also be noted that if it is prima facie dismissed because of the non-appearance of the appellant, then it can be reinstated when sufficient cause is being presented before the Appellate Tribunal and the bench accepts such a sufficient cause. In a situation where the respondent does not appear for the hearing, that is, there is the appellant who has preferred an appeal, and an appeal is always made against, say for example, by the taxpayer against the Commissioner of Central Tax. Then if the respondent does not appear for the hearing, then the GST Appellate Tribunal may hear and decide the case ex parte. That is what is also provided in Rule 43. The cause title of the appeal, the procedure has been provided and followed in Rule 18, which says the cause title, that is the title of the entire appeal shall say, in the Goods and Service Tax Appellate Tribunal, and the appeal shall be divided into paragraphs which shall be numbered consecutively, and each paragraph shall contain a separate fact or allegation or a point. So the way it has to be constructed is that if in serial number 1, the violations of principles of natural justice is disputed, in serial number 2, the validity of the show cause notice on the grounds of limitation would be disputed. In ground number 3, there could be a ground to say that the relied upon documents were not submitted along with the show cause notice, and therefore the validity of the show cause notice is yet again disputed. Ground number 4 to say that on a legal basis, this case should have been a fit case only under section 73 and not a fit case under section 74. That there is no issuance, that there is no case of fraud, willful misstatements, or suppression of facts. This could be something in ground number 4. Ground number 5 could say that the order per se is not a speaking order at all, because the detailed submissions made in the grounds of appeal and also before the first appellate authority and also in the reply to the show cause notice were not considered by the first appellate authority or the adjudicating authority, as the case may be. Or ground number 6 could go to say that at the factual level, the show cause notice has grossly erred in considering the value of table 8A, which has a very erroneous figure, but whereas the table GSTR 2A figure itself reflects a much higher figure, and therefore at the factual level it could be disputed. So each of the grounds could have a very different fact, a different allegation, or a different point altogether. That is what Rule 18, the procedure of the GST Appellate Tribunal rules, very clearly provide for. Rule number 19 goes to say the form of appeal shall set forth concisely under distinct heads the grounds of appeal. The grounds of appeal has to be distinct from the facts, and the grounds of appeal, the ground shall be numbered consecutively and shall be typed in double space of the paper. So what is the spacing, whether it is spacing 1 or 1.5 or 2 spacing needs to be given. And in what type, what should be the size of the paper? Should it be a full scale paper? Should it be a letter size paper, or should it be an A4? Very clearly goes to say the form of the appeal, cross objections, reference applications, the stay, or any other miscellaneous application shall be typed neatly in double spacing of the A4 size paper. The size of the paper is always A4. Important that it shall be duly paged, that is the page numbers are clearly given. And based on the page number, there is an index at the front of the entire appeal set, and it is tagged firmly along with the form of appeal. A separate folder together is being given. The form of the appeal along with the facts of the case, the grounds of appeal, any other miscellaneous applications related to the same. Say, for example, that is what we call it as the interlocutory applications, and all other relied upon documents need to be combined together. So these has been the 15 points, a recap of what we have been discussing in part 1 of the session. Now we dive deeper into the remaining legal provisions as is contained in the GST Appellate Tribunal procedure rules, and having discussed up to rule number 19, we move forward with the remaining rules. So rule number 19, as you could also see, spoke about what is the form of appeal. So the form of appeal, that is the form in which the appeal has to be filed to the GST Appellate Tribunal, is very clearly prescribed in the rules, and the form is GST Appeal 05. CGST rules very clearly provide for these rules, and the form of appeal is GST Appeal 05. So what is it about these rules, about this form? Rule 21 has multiple sub-rules, so we will break it into multiple minor components. We will read this along with any other related legal provision with Rule 21, and then break it into each of the sub-rules. So Rule 21 has up to Rule 6 sub-rules. Rule 21 sub-rule 1 says that what are the documents to be accompanied along with the form of the appeal. When I am filing the appeal in form APL 05, I have already seen in rule number 18 and rule number 19 to say that I need to give the facts of the case, the grounds of appeal. These are part and parcel of the form APL 05, and how it has to be given. It has to be given in double spaced in an A4 size paper. What are the other additional documents that have to be submitted along with the appeal form? First and foremost is the certified copy of the order appealed against. So the appeal before the GST Appellate Tribunal is preferred against already an existing order. Say, for example, it is the order passed by the first appellate authority. Let's assume it is the Commissioner appeals. So the order passed by the Commissioner appeals is not in favor of the taxpayer, and therefore the taxpayer prefers an appeal under the provisions of section 112 before the GST Appellate Tribunal. So the certified copy of the order passed by the Commissioner appeals has to be provided. So certified copy of the order appealed against, in the case of an appeal against the original order passed by the adjudicating authority, right? If at all it is not the first appellate authority, if at all you are directly going before the against the order of the original adjudicating authority, then that copy of the order, where if it is filed against an order passed in appeal, there shall be a certified copy of the order passed in appeal along with the order of the original authority. So when you are going against the order of the first appellate authority, then you need to give the order of the appellate authority and also the original adjudication order. Both needs to be given along with all the relevant documents, including the relied upon documents. All the relevant documents to mean, that is, if there was an appeal filed before the first appellate authority, then such copy of the appeal form, the order by the adjudicating authority, reflecting back to say the reply to the show cause notice, the show cause notice copy. If at all there was a pre-show cause notice, then such documents, all documents relating to such the entire case. If you really look into the case ID in the GST portal, all the documents relating to a specific case are generally grouped into a case ID. Even if you verify and go to our Zentax portal, all the details and documents relating to a specific case are grouped together. So all the documents, relevant documents relating to the case, has to be necessarily forming part and accompanied along with the form of the appeal. So that is one of the most important criteria. So when we talk about certified copy, what does certified copy actually mean about? The question clearly gets raised when we read the proviso to Rule 21 Sub Rule 1. The proviso to Rule 21 Sub Rule 1 goes to say, provided that where an application is filed under the direction of the Commissioner, that is, the appeal is filed by the department, the copy of the order appealed against shall be an attested copy instead of a certified copy. Now, the question comes, what is going to be the difference between a certified copy and an attested copy? If the department is going to file an appeal, they will be giving an attested copy. But whereas if the taxpayer has to file an appeal, it has to be a certified copy. So what is necessarily is going to be a certified copy, and who has to certify that as a certified copy? Rule 2, the definition portion of the GST procedure rules, Rule 2 Sub Rule F, clearly defines what is a certified copy. Certified copy means an original copy of the order or the documents received by the party or a copy thereof duly authenticated by the concerned department or a copy duly authenticated by the authorized representative of the appellant or the respondent. So certified copy means, first and foremost, it is the original copy of the order. So you got only one original copy of the order. Say, let's assume it was a signed physical copy of the order which was served on you. You got only one original copy of the order. That original copy of the order needs to be given as a certified copy as an accompanying document to the form of appeal before the GST Appellate Tribunal. If you do not want to give the original copy of the order, then you need to get it authenticated. That is to mean certified by the department or by the authorized representative of the appellant. We already discussed who can be an authorized representative, but so I am not discussing much into it in depth now. But therefore, it is very clear that the appellant, the person filing the appeal themselves, for whatsoever be the reason, has been removed, has not been included as the person who could certify the order which is being appealed against. Therefore, if the appellant himself is filing an appeal even without an authorized representative, then he needs to get the copy of the order authenticated by the department. If it is going through an authorized representative, then the authorized representative himself can say that this is the certified copy of the order. Right? So next is about, should I certify only the copy of the order or should I need to certify each of the copies, each of the relied upon documents also, should it be certified. This is contained in rule number 34 of the GST rules. The copy, each of the appeal and the relevant documents along with the relied upon documents shall be provided to the respondent as well as to the concerned commissioner as the case may be as soon as they are filed. Okay, fine. So this talks about that rule 34, that talks about that the copy of the appeal along with the relied upon documents, certified copy, all these things are fine. Should I file it only to the GST Appellate Tribunal? No. You are supposed, you are required under Rule 34 to provide a copy of the same to the respondent also. Is it sufficient to file it against to the respondent, that is the person who against whom I am filing an appeal? No. Also to the commissioner as well as to the concerned commissioner. So this casts a very important responsibility that the procedure very clearly requires that not only you file an appeal before the GST Appellate Tribunal, you also serve a copy on the respondent and you are required to give a copy to the commissioner as well. Talking about this attestation, the president, that is the president of the GST Appellate Tribunal, may, by a general or a special order, allow attestation of the documents filed along with the application, along with the appeal, can be attested by a gazetted officer or such other person as may be authorized by the president also. So we had in one specific provision under rule number 21, under rule 2 clause F, that it can be attested only by the authorized representative or by the department themselves. But under rule 21 sub rule 5, it goes to say that if the president allows, then it can be attested by any other person also, by, say for example, any other gazetted officer also. So all these documents, it is extremely very important that they are very clearly legible, duly paged, indexed and tagged firmly. This is something which we already saw in the procedure to the rules in rule number 19. Rule 21 sub rule 6 also very clearly says that it shall be clearly legible, paged, indexed and tagged firmly. What happens if some page is not really proper? If some paper is torn, if the document itself is damaged, then what happens? Rule 30 very clearly provides where a document produced, which is along with the pleading, is defaced, that is not of proper color, that it is very faded, torn, or in any way damaged, that it requires a special notice, then it is extremely very important that the person who is producing such kind of a document makes a special mention. What is a mention? Mention to mean that at the beginning of the hearing itself, it has to be specifically placed before the bench that such and such document is defaced, torn or damaged. Its condition and appearance shall be made by the party. The mention regarding it shall be definitely made before the bench and it should also be mentioned in the index itself, right? Index of such a pleading, and the same shall be verified and initialed by the officer authorized to receive the same. So that officer who is receiving such a document shall confirm, find that it is defaced, torn, still it is being accepted. So 21 sub rule 1 spoke about what are the documents. 21 sub rule 2 very clearly goes to say again that rule 110.5, which goes to say the minimum required fees, that is a minimum of rupees 5,000, maximum of rupees 25,000, but the fees shall be rupees 1,000 for rupees every 1 lakh. Rupees 1,000 for every 1 lakh that needs to be paid is again reinstated in rule 21 sub rule 2. That is what is contained in rule 110.5 of the CGST rules. This is something which we already discussed. The amount of fee we already discussed. Rule 21 sub rule 3 goes to say that in case of non-filing of the documents which is prescribed under this rule, that is to say all the documents which is required, relied upon documents has to be filed, then the registrar may return the specified documents, right? He may return the specified documents or the sets of documents, multiple sets were filed, then he may receive it, he may return it, and with the direction that he will receive it only after rectification of the defects to the satisfaction of the registrar, right? So this is very important that the appeal that is filed is very proper, and if it is not proper, it would be written by the registrar itself. If you refile, then it would be assigned only a new number and not the old number. That is, the date of filing itself will also get extended. That is also something which is being brought out through rule number 21, sub rule 3. So what power does the registrar have? Before we complete rule 21, we also reflect back to rule 24 of the GST rules, which goes to say, if the registrar scrutinizes, or if on the scrutiny, every time the registrar is bound to scrutinize the appeal, when he scrutinizes the appeal, he finds that the appeal or the document is defective. Then he can provide time that it shall be rectified within a period of 7 working days from the date of return of the appeal document. Then it shall be placed before this registrar, who shall accept whether it is okay or not. He may extend the time also for a period not exceeding 30 days. So up to 30 days, the registrar may give time for us to rectify or amend any of the mistakes which is existing in the appeal or the supporting documents. Where even after such time that the defect which is communicated is not rectified, is not removed, then the registrar may decline to register the appeal itself. He may outrightly say this appeal will not be taken into consideration. But where he has given an opportunity for the personal hearing and still he is not satisfied, the registrar does not end the matter there, but he shall list the defects for hearing. Therefore, even if it is a defect, that defect petition will also come before the bench. The bench may consider and the bench may hear the party and say, fine, I will accept to register the appeal, or they may reject the said appeal. The bench has all the power to accept or to reject the appeal also. This is not on any of the merits, but this is only when there is a defect in the filing of the appeal document. If there is, say, for example, a page numbering issue, 1, 2, 3, 4, 5, 6, 7, 8, instead of page number 9, we erroneously entered it as page number 10. For this kind of very small mistake, should it be returned? Should the appeal prima facie be rejected? Right? Ex parte amendments in every appeal or application, arithmetical, grammatical, clerical, and such other errors may be rectified on the orders of the registrar without notice to the parties. Very small trivial mistakes, the registrar themselves can make some corrections. But if after the appearance of the respondent, after the hearing is being done, then there shall not be any of these minor corrections also. One minute, please excuse. So multiple situations, multiple places where the appeal is being scrutinized by the registrar or it is being rejected. We saw about rule 24. We also have rule 32, which says the registrar, after giving sufficient cause, at its discretion, accept an appeal even when it is not accompanied by the documents referred to in rule 21. Rule 21 is where we started to say the documents, what needs to be accompanied along with the appeal. The registrar may accept it, right? Give some time for the appellant to make the requisite amendments, but the maximum time given shall not exceed 30 days. Or the registrar may reject the form of appeal, right, if they are not produced. So both powers are with the registrar, and therefore it is extremely very important that the appeal which is being filed is filed in complete compliance of what is provided in the GST procedure rules. And also, you need to know what are the latest directions that has been issued by the president of such tribunal. Because the president of the tribunal is empowered to issue directions and to lay down the guidelines, the rules of the functioning of the tribunal. Say, for example, if the bench or if the president of the tribunal decides that it has to be in such specific format, or if some specific undertaking is required, then as well those procedures, even if it is not laid down by the GST rules, it is binding, because we saw already in the very beginning of the session earlier that these rules are not which are made by the rule making authority. The general rule making authority in the CGST rules is the Central Board of Indirect Taxes and Customs, but whereas with respect to the GST procedure rules, the tribunal themselves form the rules. The tribunal themselves form the rules. The president, they themselves form the rules, and therefore the amendment to the procedure rules or any deviation or modification, any additions can be made by the president of the tribunal themselves. So this is again as well the president may in his discretion. So the registrar has some limited set of powers. The president has another set of powers. But all these things really go to say that it is extremely very important that an appeal to the GST Appellate Tribunal is very clearly filed in the form in which it is provided, in the manner as is compliant with the procedure rules. So even when you go through this rule, how much ever they say that those minor mistakes, no mistake should be there. If you see this screenshot, how many of you can find something blatantly as a mistake? This is a screenshot from the PDF file of the rules as well. Just by looking at this screenshot, are you able to find out any apparent mistake? Any mistake which is apparent on record, which warrants a rectification under the provisions of the various rules? Any mistake that you could apparently see? Any mistake from the audience? Good, right? Thank you, Murtuza. Point number 4 is missing. Exactly. Not that I really cropped out point number 4, but point number 4 per se has been missing from the rule 32 per se. From the PDF document as is notified in the Gazette itself, sub rule 4 of rule 32 of the GST procedure rules per se is missing. So this really brings out to say that when there are minor mistakes, then it has to be ignored, considering what is the matter that we already discussed, right? So it is extremely, that is what these mistakes are also bringing out, is what we understood once. Right, so who should sign the appeal? The appeal shall be signed by the party, by the appellant. So it is very important that the appellant signs the appeal, and at the bottom of every appeal form, there shall appear the name and signature of the authorized representative also. So at the foot of every appeal, there shall be the name and the signature of the authorized representative. But still also, it shall be signed and verified by the party concerned, not just by the authorized representative. It shall be very important that the party, that is the appellant, also signs the appeal. Production of authorization, that is the power of attorney when it is to be appeared by a chartered accountant, or a vakalatnama which is to be appeared when it is appeared by an advocate. So there, what is the importance or significance of this authorization? Where it is to be appealed, where another person is to be given an authorization, then such authorization needs to be duly provided for, and the registrar may satisfy themselves by calling upon additional documents to verify whether the authorization is very duly, whether it is proper or not. So a true copy of the authorization letter needs to be submitted, a true copy necessary to mean the original generally, or if the copy of it to say that it is a true copy needs to be attested by the person who is issuing the authorization themselves. More about the authorization is something which we would discuss in the immediately forthcoming slides as well. Translation of the documents. There are situations in selected states where the notice is issued in a language which is not English. That is, the notice itself is issued in the Hindi language. In which situation, the GST procedure rules mandate that the document shall be translated in English. So it shall be important that English translated document is submitted, and until all the documents are in English language and such requisite number of copies are filed before the appellate tribunal, and it is duly authorized by the attested by the authorized representative, certified by the authorized representative, then you cannot really expect the hearing to really move forward. It is important that the documents is properly filed, and proper filing will require that if a language of a document is not in English, then it needs to be duly translated also. This is another terminology that has been that has to be well appreciated and understood with respect to the GST procedure rules. That is, what is an interlocutory application? An appeal petition is the main application, or the appeal is the main document, and in addition to the appeal, whatever are the supporting things, say for example a condemnation of delay beyond a period of 3 months, if an appeal is going to be filed, then you would generally file what is called as condemnation of delay. Or you have filed an appeal for a substantial amount of refund. There is an amount of refund to the extent of rupees 50 crores which is pending before the various authorities, and therefore you are filing an appeal before the appellate tribunal. Since the amount involved is high, you want an early hearing. These are some of the cases what we call as an interlocutory application, an application for stay of the demand, a specific direction to be issued to X authority, rectification in the order, appeal, an application made for a rectification, which is a mistake apparent on record, for early hearing, condemnation of delay, an exemption from production of the copy of the order appealed against. The copy of the order is in the hands of certain person, therefore I am not able to produce a copy of the order, but having understood the facts and the circumstances of the situation, I am filing an appeal only with the available details. I am praying time for extension of time, right? So for all of any of these things, then as well, all the information what is prescribed in the GST form 01. GST form 01 is what is provided in the GST procedure rules, and those details has to be necessarily a part of these interlocutory application, and shall be filed, if at all, even along with an affidavit. So the affidavit is a concept, authorization is a concept. These are some concepts which comes in multiple places across the GST appellate tribunal rules. And with respect to an affidavit, okay, we will go to an affidavit immediately thereon. But when it comes to an affidavit, it is extremely very important to understand that it is based on the Code of Civil Procedure, and the person who's giving an affidavit needs to get it notarized. The person who's giving an affidavit is called as the deponent. So when the deponent does not know the language, then it has to be translated, and that needs to be also very carefully noted in the affidavit. So affidavit has a very significant role before the GST appellate tribunal, and therefore people even filing an appeal before any other forum can also definitely rely on using an affidavit as a document of evidence. So grounds of appeal. What are the grounds of appeal that I have already placed in the form of appeal, right? Should I confine only those at the time of hearing? Shall I take something more as well? The rules very clearly provide that without the permission of the tribunal, that is what they say, shall not except by leave of the appellate tribunal. What is the terminology? Leave of the appellate tribunal to mean without the permission of the appellate tribunal, urge or be heard in support of any grounds not set forth in the form of appeal. In the form of appeal, we did not put forth one specific point at all. That is, we did not challenge the validity of the notice on the grounds of limitation. When the grounds of appeal does not talk about the grounds of limitation, should I confine? Should the appellate tribunal confine only to those grounds? Right? The rule very clearly goes to say the appellate tribunal shall not be confined to the grounds set forth in the form of appeal. or those taken by leave of the appellate tribunal under these rules. Why is it basically all about? It is expected and it is always presumed that the members of the GST AT are well reasonable and well informed about the various developments in law. Say, for example, someone filing an appeal has not even challenged the validity of the show cause notice on the grounds of limitation. But the members of the bench have noted that this order or the prima facie show cause notice is barred by limitation. Then the appellate tribunal should not be restricted to say that just because the appellant did not raise this ground, I will not consider this. The appellate tribunal themselves can consider that ground and give a favorable order also. But when they go for any other ground, then the affected party also needs to be given a sufficient opportunity of being heard. Hearing of the appeal. So on the date of the hearing may be heard or may be adjourned also, right? The appellant shall be heard or any other date to which the hearing may be adjourned. It can be adjournment. We have a separate provision. The appellant shall be heard in support of the appeal. So how does it practically happen? Generally, the appellant makes the first submission. We challenge, let's assume, on the very same grounds that I already told you about. That is challenge with respect to the grounds of limitation, challenge with respect to the constitutional validity of the legal provisions, challenge with respect to the applicability or the invocation of section 74 and only the notice to be under section 73. So you have multivarious grounds. You raise all the submissions together before the GST Appellate Tribunal, before the bench. Once you have made all these submissions before the bench, the respondent, let's say the departmental authority, makes their submission. After they make the submission, is it over, or do you have one more opportunity to counter the submissions made by the respondent? That is where Rule 41 sub Rule 2 very clearly goes on to say the appellate tribunal shall then, if necessary, hear the respondent against the appeal, and in such a case, the appellant shall be entitled to reply. It's extremely very important. The assessee shall be entitled to reply. But whereas it is not mandatory to hear the respondent, only if the appellate tribunal thinks that it is necessary, it shall hear the respondent against the appeal. Right? So generally, the appellant always has the first right to make their submissions. And if the respondent needs to make a submission, they definitely have the right and they can make their submissions. And after the submission is made by the respondent, then we also have the additional time, additional opportunity to entitlement to reply to the counter which is being made by the respondent also. Can I bring in additional evidence? Can I bring in additional evidence during the course of hearing? The parties to the appeal shall not be entitled to produce any additional evidence. So therefore, outrightly, Rule 45 sub Rule 1 goes to say no additional evidence can be considered by the appellate tribunal, unless and otherwise it was already produced before the adjudicating authority or the first appellate authority. But whereas the proviso immediately that follows goes to say that if there was sufficient cause or that the adjudicating authority or the appellate or the revisional authority did not give the opportunity at all to present such evidences, then the appellate tribunal may record the reasons that it is considering an additional evidence, though it was not presented earlier, it is now considering an additional evidence, then only it can allow such documents to be produced. So generally, when you are submitting a document or an evidence, place it before the first adjudicating authority itself. That is, at the time of reply to the show cause notice itself, please make sure that the evidences are all well compiled and presented so that at a later point in time, there is no ambiguity that such an evidence will not be considered per se. Right? If at all there is any evidence, any additional evidence, any document which is being produced under the provisions of sub Rule 1 of Rule 45, then the appellate tribunal, it can be done before the appellate tribunal or before such authority as the appellate tribunal may direct. That is, when I want to produce a very voluminous factual details, the Appellate Tribunal might not have the time to look into all the documents. The Appellate Tribunal, the GST might directly say, place such documents before the superintendent, the range superintendent. I will remand the case to the range superintendent for the limited verification of these documents, and it would be made before the relevant Appellate Tribunal. Once the evidence is being compiled and it is being submitted back, then that case would be taken up further. Even the Appellate Tribunal itself can also ask for certain specific documents. So I already spoke to you about an affidavit, the significance of an affidavit, rule number 78 to rule number 83. So almost 6 rules in detail talks about the affidavit, all small rules talking about how an affidavit needs to be produced. But talking about the production of an evidence by affidavit, the rule 46 very clearly goes to say the GST 80, they may direct the parties to give evidence by affidavit, right? So where there are submissions which are being made to say, my lordship, I have not done this at all. That is, the appellant has not done any of these transactions. This does not pertain to the appellant. Then when at all it is only oral, the GST Appellate Tribunal may say, give these submissions in the form of an affidavit, then maybe we will take it on record. Notwithstanding anything contained in sub-rule 1, that is a non-obstant clause, an overriding provision to say, where the Appellate Tribunal considers that it is in the interest of natural justice, it may cross-examine of any of the deponent, right? So when there is a conflict or when there is something to be proved, then a cross-examination of the affidavit, the person who gave the affidavit can be conducted, even using the latest information technology facilities like video conferencing. So, or maybe they may ask them to appear in person. So just because an affidavit is produced does not mean the person cannot be called for. Even then the person can be called for based on the sub-rule 2 of rule number 46. So, appearance of an authorized representative. So, unless the authorized representative files a vakalatnama or a letter of authorization, which shall contain the details as is contained in GST 80 form number 04, then he shall not be allowed to appear. But once, so Gunasekaran sir, the right question now, in all over India, whether tribunal office has been formed, sir, right? So tribunal office is not yet formed, sir. So the tribunal is in the latest forms of formation, and therefore we felt it is very important that immediately after its constitution, immediately after its formation, then the appeals need to be filed, and therefore we need to really inform you well in advance because the rules have already been notified. But as of now, the tribunal is yet to be formed across the country, right? So the power of attorney letter or the vakalatnama has to be containing the details as is contained in GST 80 form 04, and it has to be, the format need not be in the same format, but all the information as is specified therein needs to be captured. Once you appoint an authorized representative, there are a couple of key things that you need to look into. Appointment of an authorized representative has to be done with extreme due caution, particularly before the GST Appellate Tribunal, for the reason that once an authorized representative has been appointed, you have engaged, then the appellant, the party may be restricted to make their presentation before it. Once you have appointed an authorized representative, the authorized representative shall only make his submissions before the Appellate Tribunal and not the party themselves. So that might be, that is what is also contained in rule number 75, and therefore when there is an authorized representative, then there could be a restriction on the party's right to be heard. Change of authorized representative also has its own set of difficulties, that you are authorizing X to be your authorized representative. Thereupon, you want to change the authorized representative to Y. Then in such a situation, rule number 73 requires a written consent from X, the person from whom you are changing, to Y. So a written consent from the first appointed legal practitioner or authorized representative is required when you are going to change. Where in a situation the written consent is not possible to be obtained, then as well there is a very specific procedure laid down to say that it shall be placed before the tribunal and the appellate tribunal only on the permission and after revocation of such vakalatnama. Then it can be considered for a fresh hearing of the new counsel at all. So whenever there is appointment of an authorized representative in respect of the filing before the GST Appellate Tribunal, please be extremely very careful when it comes to the taxpayers, and therefore change might be a little complicating. Restrictions on appearance, that is to say, where this I will just inform, say for example, in the case of fake ITC cases. Say for example, this can be better interpreted in the case of a fake ITC case. In the case of a fake ITC case, you are representing the supplier, and at the time of making a submission on behalf of the supplier, you go to say it is not the fault of the supplier, but it is a fault of the recipient. You put the blame on the recipient. Whether the same authorized representative can appear for the recipient also and go to say, no, it is only the supplier's fault. No, it is not possible. It is very clearly say, it is if it is opposing the interest of the first client, then you cannot appear for the second client. So that is also which is part of the GST 80 rules itself. So these are some of the very practical and important aspects that one needs to consider when we are going to file an appeal before GST Appellate Tribunal rules. As Gunasekaran sir has also put forth that very important question, that whether at all it is formed, it is in the very advanced form of its constitution. Is it the entire comprehensive discussion of the GST Appellate Tribunal rules? As far as the part of the taxpayer is concerned, we are confident that the discussion in part 1 and part 2 together encompass a very comprehensive discussion of the entire GST Appellate Tribunal procedure rules. There are certain aspects of the GST 80 rules which relate to the procedure to be followed by the tribunal. That is how they have to maintain the documents, how they have to issue the cost list. All those are procedures which pertain to the practical aspects of the tribunal or the department per se, and so those aspects have not been touched upon. But whereas what we have discussed in part 1 and part 2 are substantially the most important aspects of the GST 80 rules, directly relevant to the taxpayer relating to filing of an appeal. So the GST Appellate Tribunal is expected to provide a substantial relief to the taxpayers in respect of the various appellate orders which are against the taxpayer or the department as such. So a lot of clarity is expected to come once the appeals are filed before the GST Appellate Tribunal. It's going to be a very interesting practice. For any of the other practical tips and tricks that you would want to know, or you have any clarifications thereupon, it is always a pleasure to connect with you in person. This is my personal contact number. You always have the contact number of Zentax Clinic where you can always get in touch with us. So for any solutions, any support with respect to any filing of appeals, reply to notices, or personal representations before any forum, please do get in touch with our support team or any of our team members for any clarifications relating to the GST Appellate Tribunal. Always a pleasure to connect with each one of you. So it is extremely a pleasure having you all at our 75th session of Zentax Talks. And today also happens to be a special day where the 100th Zentax info bytes were also posted. So 100th info byte where we have been consistent in our WhatsApp channel, in all our social media. Do follow us on all our social media channels, including our WhatsApp channel, to learn and get yourself updated on the latest updates relating to GST. Thank you for your active participation. Looking forward to your participation in Zentax Talk 76 and also the forthcoming sessions. Thank you, everyone.